Thank you very much, and thank you to you and to the Asia seminar. I'm truly honored to be here today. As was mentioned, I was counsel to the Philippines in its recent arbitration with China concerning maritime rights in the South China Sea. Though today I will be speaking strictly in my personal capacity, and so nothing I say should be contributed to the government of the Philippines. My task today, I think, is a tall one. I will try and give an overview of the tribunal's award that was rendered in July of this year. The award deals with a host of very interesting international legal issues, ranging from the procedural, including the effect of non-appearance by one of the litigants, the role of the tribunal in such circumstances, how a tribunal should address historic evidence, scientific evidence, and a host of equally fascinating substantive legal issues, including the jurisdiction of tribunals under the Convention on the Law of the Sea, the legality of China's declaration of what's often referred to as a nine-dash line, claiming maritime rights within those waters in the South China Sea, the entitlements of maritime features under international law, navigational safety issues, obligations of cooperation that are imposed by the Convention, and a host of other equally interesting international substantive issues. All told, the tribunal issued two awards, one dealing first with jurisdictional issues, and the second, a final award, which I mentioned was rendered in July of this year. In total, they came out to about 650 pages. Now, I'm a lawyer, so my math should be inherently suspect, but given the time that's been allotted me, I calculate that comes out to approximately 32 and a half pages per minute. So that leaves me a choice. I can either speak really quickly or be selective. I hope you'll forgive me for being selective. So I'm planning on focusing on three issues that I think really form the main principal issues that were dealt with by the tribunal. First, the lawfulness of China's declaration of a nine-dash line. Second, the maritime entitlements of insular features. In other words, whether very small features are entitled to the full panoply of rights up to 200 miles that are accorded to larger features. And then finally, environmental issues that are implicated by China's activities in the South China Sea. But before proceeding, I think it makes sense to provide an overview of some key concepts that are codified by the UN Convention on the Law of the Sea. The convention itself is a widely ratified multilateral treaty that the international community concluded in 1982, became effective in 1994. It deals with a host of law of sea-related issues, everything ranging from marine scientific research to piracy to environmental issues. But some of the really important issues that the convention regulates concern the spatial scope of entitlements that a state is entitled to under international law in the waters adjacent to its land territory. In particular, the convention establishes a maximum outer limit of a 12-mile territorial sea. In the waters within the territorial sea, a state is entitled to full sovereignty, subject to certain caveats, such as the obligation to provide innocent passage to passing ships. The convention also establishes other very important innovations in international law. These include the establishment of a 200 nautical mile entitlement to an exclusive economic zone, within which a state is entitled to exercise certain exclusive economic rights. Similarly, a state is entitled to up to 200 miles of continental shelf, and in some circumstances, depending on the geology or geomorphology of the area, to extend that to a further 350-mile outer limit. I like to think of the exclusive economic rights that are provided by the EEZ and the continental shelf as concerning fish, the exclusive economic zone, and oil and gas, namely the continental shelf. In addition, the convention provides that insular features, in other words, islands, are entitled to a full 200-mile exclusive economic zone or continental shelf, with a certain exception that we'll talk about in a bit more detail in a few minutes. Those are very small features known as rocks, which are only entitled to a 12-mile territorial sea. Before proceeding further, I think it makes sense just to say a few words about the geography of the South China Sea region, because the geography of the area plays a really crucial role in understanding what the tribunal did. So this is the South China Sea. It's known in the parlance of the law of the sea as a semi-enclosed sea. You can see it's bounded to the north by China. The southernmost part of what we could call undisputed territory that belongs to China is Hainan Island. Then bounded to the east by the Philippines, proceeding clockwise by Malaysia, Indonesia, Malaysia again, and then on in the west by Vietnam. Some of the key insular features include the Parasols, which are located in the north, Scarborough Shoal, which is located in the east, and then finally the Spratly Islands, which are a series of very small insular features that are located in the southern part of the South China Sea. So, one of the important things to know about the South China Sea is that many of the island features I just mentioned have been the subject of competing sovereignty claims for many years by the various littoral states. And that had been the situation for quite a long time. Things came to a head and changed in rather dramatic fashion in May of 2009 when China submitted to the United Nations diplomatic notes in response to submissions by Vietnam and Malaysia to the UN Commission on the Limits of the Continental Shelf. Those submissions concerned claims regarding the extension of the continental shelf of those states beyond the 200 nautical mile limit that is automatically provided for under international law. But what's important for present purposes is that the diplomatic notes that China submitted to the UN claimed not just sovereignty over the various island features of the South China Sea and what it referred to as those features adjacent waters. It also claimed sovereign rights and jurisdiction over what it referred to as the seabed and subsoil thereof. And then it said that those areas, in other words, the areas that are considered the relevant waters where sovereign rights and jurisdictions were being claimed, were depicted on maps attached to China's diplomatic notes. And you can see a copy of the map depicted on the screen now. What's most important is that the waters claimed by China are bounded by what's known as the 9-dash line, which you can see extending in the northeastern corner and then extending down through to the...
Don't point at your eye.
Oops. Yeah. Extending through, so it follows this course through the along the coast of Malaysia, and then close to the coast of Vietnam. It soon became apparent that the rights that China was claiming within the 9-dash line were claimed to be exclusive. And China took various actions that sought to enforce those claims of exclusive rights, including obstructing offshore oil exploration activities by both the Philippines and Vietnam, and by also claiming the exclusive right to regulate fishing within those waters. So that was the situation that the Philippines and the other littoral states of the South China Sea found themselves in 2009 and in the ensuing years. That prompted the Philippines to file a case before an international arbitration tribunal that was constituted under the convention. Now, to give you a little bit of context, among the things that the convention does is provide for a very sophisticated, compulsory international dispute resolution procedure that allows states to object to and challenge as unlawful interpretations or applications of the convention by other states, subject to certain jurisdictional restrictions, which we can get into if we like. But the crucial point is that the compulsory dispute resolution procedures created by the convention concern only issues relating to the law of the sea itself and do not pertain to other issues, including land sovereignty issues. So the Philippines crafted its claims before the tribunal as being restricted only to law of the sea issues, and told the tribunal was not asking for or requesting any determinations as to the which state would lawfully exercise sovereignty over the insular features of the South China Sea. So the first issue that the tribunal needed to deal with concerned what was the nature of the 9-dash line that China was claiming. And this, including whether it was in compliance with UNCLOS. Now, as we said before, UNCLOS provides for a 200-mile limit for maritime claims in the EEZ and continental shelf. You can see what the 200-mile limit would be from Chinese territory extending from Hainan Island by the red line following there. What's immediately apparent is that China is claiming an extensive area of the South China Sea that lies well beyond 200 nautical miles from undisputed Chinese territory. To be sure that China also claims sovereignty over the very small insular features in the Spratlys and in Scarborough. But as the Philippines maintained, those areas can only sustain a 12-mile territorial sea limit, not a full 200-mile continental shelf or exclusive economic zone. So as I said, the first issue was whether China was making a claim to waters that lie beyond its automatic entitlement under UNCLOS, and the tribunal found that, in fact, it was, that it's claiming areas that lie well beyond 200 nautical miles from any undisputed Chinese land territory. The second issue the tribunal needed to deal with was what was the basis for China's claim. Based on Chinese diplomatic statements and actions, it became apparent that China was basing claims not under UNCLOS, but claims that are founded in history. Chinese authorities, including in diplomatic communications, had maintained that China's rights were based upon rights that were formed long in history, dating back in some cases thousands of years. So the question faced by the tribunal was, can a state maintain a claim after the ratification of UNCLOS to areas of the sea that lie beyond what it would ordinarily be allowed to claim under UNCLOS based solely on history? And the tribunal answered that question as no. The convention is a comprehensive package deal that comprehensively regulates the types of claims that states may make. And that after ratification of UNCLOS, prior claims based in historic rights have been vitiated. That after UNCLOS, a state may only claim rights based upon rights established by the convention and no other. But the tribunal also looked at a secondary issue, which was, even if one could assume, for the sake of argument, that historic rights claims can survive the ratification of UNCLOS, could China maintain a historic rights claim? And it looked at this issue by examining historic rights under customary international law, which it determined really required two things. First, that a state exercise exclusive rights over an area for a long period of time, and that other states acquiesce to those claims of exclusive rights. And the tribunal looked at, had this been the case in the South China Sea, and determined that the answer was no. And in fact, for hundreds, if not thousands of years, all of the seafaring communities of the South China Sea have made extensive use of the South China Sea's waters, and that those uses were not exclusive, but were consistent with the area's status as high seas. In other words, states were exercising the rights of navigation, the rights of fishing, consistent with its status as an area that belonged to no state. One of the great perks, for me at least, of practicing in this area of law is that it allows me to indulge in my interest in historic maps. And one of the things that the tribunal asked the parties to do was to collect and present for consideration all of the historic maps they could find relating to claims in the South China Sea. So what you can see now before you is the earliest map that we could find. This was a mid-12th century stone etching from the southern Song dynasty. And what's interesting about this map is that when you overlay it over a map showing the geography of the South China Sea, you can see that China was making no claims beyond Hainan Island, which you can see right here. And what's equally interesting is you see exactly the same claims to in the South China Sea throughout the ensuing several centuries. This is a map that depicts, that's the official Chinese depiction of itself from a provincial atlas that was intended to be a comprehensive atlas of the Chinese Empire at this time. And once again, what you see is that China was really only making claims only as far south as Hainan. Same thing can be seen in a map from the late Qing Empire. Again, claims extending no farther south than Hainan. I'll just show one last map. This one is particularly interesting. It's from 1933. It's the first map where China made any claims south of Hainan. In this case, a claim extending only as far as the Paracel Islands. That's consistent with the diplomatic note that China had sent to France in 1932, the prior year, making clear that the Paracels formed the southernmost part of Chinese territory. I won't belabor the point with any more maps, but the essential point is that the tribunal determined that China had not made any claims to exercise exclusive rights over history, and no states had acquiesced to those rights. And so even if historic rights claims could survive the conclusion of UNCLOS, China would be unable to maintain that it ever acquired historic rights to the waters of the South China Sea. I'll move now to address briefly the remaining principal issues that the tribunal addressed. The first concerns the entitlements of insular features. Article 121 of the convention deals with the issue of islands, and it does it really in two parts. First, it defines an island as a naturally formed area of land that is above water at high tide. And it provides that islands, like continental coasts, generate full maritime entitlements of exclusive economic zone and continental shelf. But then it carves out a subcategory exception for island features referred to as rocks, which are defined by the convention as features that cannot sustain human habitation or economic life of their own. That's found in Article 121, paragraph 3, language that has vexed international lawyers really since the conclusion of UNCLOS and probably even before. International courts and tribunals have, until the South China Sea Tribunal, have always found a way to avoid having to interpret and apply that language. The closest a court came was in a recent case concerning Nicaragua and Colombia, which involved a very small feature known as Quito Sueño. But there was uncontested by both parties that the feature in question was only a rock, not a fully entitled island. And that was really not surprising, because I think that the feature in question was probably no bigger than this microphone. It's really a minuscule feature. So the South China Sea case was the first time that a tribunal was really called upon to interpret and apply this what might call obscure language as to what is meant by unable to sustain human habitation or economic life of its own. It had to do this in the context of a number of different types of features. Some, like Quito Sueño, were actually quite easy. This is an image of Scarborough Shoal, which is an area that has 6 very small rocky outcroppings located in the eastern part of the South China Sea. You can see pictures of some of the outcroppings on the right. You can see, quite obviously, these are features that could not sustain economic life of their own or human habitation, so that really didn't present an issue for the tribunal. What did was larger features. This is an image of a feature known as Ituaba, which is the largest of the Spratly features. This particular image is taken from images that have been collected by the Center for Strategic and International Studies. In the scheme of things, Ituaba is small. It's only 0.43 square kilometers. But unlike many of the other Spratly features, it has had a human population, albeit one that has been sustained by occupying Taiwanese military forces for several decades, and has been the subject of considerable artificial enhancement by Taiwan. So really the question that faced the tribunal was, is a feature like this a fully entitled island, or is it a mere rock, such that it's only entitled to a 12-mile territorial sea? This prompted a really lengthy discussion of the meaning of rock. Some of the questions that the tribunal faced were actually rather easy. The first was, does a rock literally have to be made of rock? And I think, perhaps not surprisingly, the answer was no. That rocks, at least for purposes of Article 121, can be made of any number of naturally occurring materials: coral, mud, sand, even guano. As long as it's above water at high tide and it's naturally formed, it can qualify as an island and thus as rock. The more vexing questions concerned what is meant by being able to sustain human life or economic activity. The court said that this needed to be determined by a reference to a subjective capacity, and that requires looking to the status of the feature in its natural state. This was a crucially important determination because, as I mentioned with respect to Ituaba, and this applies to a number of other features, features have been artificially enhanced over the years. Some which are probably on the order of size in their natural state of Quito Sueño or the Scarborough outcroppings have been made much larger by artificial enhancement by the various claimant states. So the question is, do those artificial enhancements count? And the answer was no, they don't. You need to look at the status of the feature in its natural state. Then another important question that the tribunal needed to consider was, what does it mean to sustain a human community? And the tribunal likewise said that what this really means is it needs to be a real, honest-to-goodness human community. It doesn't count to artificially sustain through massive support from the mainland, a military base or a population that's really simply there to maintain a sovereignty claim. Temporary shelter that's provided to visiting fishermen wouldn't count. Temporary economic activities like extracting mineral resources purely for the exploitive capacity of the feature doesn't count. In order to qualify as a fully fledged, fully entitled island, a feature needs to have a real, sustainable human community with everything that entails in terms of what one would expect. I could say a lot more about this issue, but I know time is running short. So I'll just spend a few moments talking about the environmental issues. The environmental issues have always been a very important case that the Filipinos brought, though it changed somewhat over time. Initially, the environmental issues concerned or focused on destructive fishing practices that China had allowed to take place, including particularly the harvesting of endangered species such as giant clams. But as the case proceeded, the environmental issues changed dramatically. During the arbitration, China began a major program to construct artificial islands on 7 features in the Spratlys. You can see those features there. These are features that are either known under the law of the sea as low tide elevation. In other words, coral reefs that are submerged at high tide, though may have some outcroppings at low tide, or very, very small rocky outcroppings that are above water at high tide. What China did was to take large industrial dredgers which are vessels with large drills that extend deep into the seabed, that have attached to them rotating teeth that rotate and pulverize the rock and coral that's located on the seabed and seafloor. The pulverized coral and rock is then extracted, transported through a floating tube, and then deposited onto reef to create artificial land. You can see a schematic of the process on the screen. This is an image of one of the dredgers that China used. It's absolutely massive, 127 meters long, 22 meters wide. The minimum dredging depth of its drill, which you can see in the front, is 6 meters, has the capacity to extract up to 4,500 cubic meters of seabed per hour. Dozens of these dredgers, perhaps not all of this size, but dozens of dredgers were employed. For example, one report had 32 dredgers seen a particular feature of Mischief Reef on one occasion. I think that was not unusual. You get a sense of the rapidity with which the dredging and artificial land creation operations took place from a series of images that I'll now display. This is an image of Subi Reef, which is a low tide elevation located in the Spratlys. To give a sense of scale, it's 5.75 kilometers in length and 3.25 kilometers in width. This is an image before any real artificial land creation took place. You can see just a tiny structure in the southwest corner right there, to give you a sense of scale. Again, this was 2012. Here you can start to see the creation of new land in January 2015. Again, to give you a sense of scale, here is the area of land that had been created up to that point. You can see various vessels, including dredgers, within the reef. This is a close-up image of dredging operations from the following month, and you can see the dredgers depositing pulverized coral material onto the newly created artificial land. This is from the following month. Again, you can see much wider, larger area of land that's been created by this point. 3 months later, the feature looked like this, and by November, it looked like this. As I mentioned, this has taken place at a total of 7 features. In total, 12.8 million square meters of new land have been created. This obviously formed a major part of our claim for environmental harm. The tribunal took its duties with respect to ascertaining the environmental impact of these activities very seriously. It appointed 3 independent experts on coral reef ecology and marine biodiversity to advise the tribunal, and based on their recommendations, determined that there have been near permanent destruction of numerous coral reefs in the South China Sea, which had immediate and devastating environmental impacts. The tribunal also found that the impacts were not limited to just the immediate vicinity of the dredging operations. This is because the South China Sea is a very interconnected, biodiverse area. So the impacts were felt in a much wider area than just the features themselves. And the tribunal determined that marine life of neighboring jurisdictions had been vastly diminished. This violated various provisions of UNCLOS concerning environmental obligations, including obligations to protect and preserve the marine environment, to prevent pollution, to carry out environmental impact assessment prior to carrying out activities that could cause environmental harm to the marine environment, and certain obligations concerning cooperation, particularly cooperation with other states in the context of semi-enclosed seas and other regional cooperation-related issues. I think we'll probably get more into the impact of the tribunal's decision in later discussions, but for now, just say that it's certainly the Philippines' hope that the award although binding only as between the Philippines and China, would, as a matter of logic, apply equally as between China and the other littoral states of the South China Sea. And that the legal entitlements that the tribunal found with respect to the various insular features of the South China Sea can be used as the basis for a negotiated settlement to the still very complex issues that divide the parties. Thank you very much.